Hello, Jai Bhim everyone. Today I am making this video for the two purposes. One is to explain about the GEO number 2 of 2004, which is also called as a Adequacy GEO, and also to make an appeal to the government of Telangana to repeal this atrocious GEO. So first I would like to read out what is the objectionable provision that is there in the GEO number 2 of 2004, which is being challenged, and through this GEO the scheduled caste and scheduled tribes employees are being subjected to injustice from last 20 years. So, what is that provision which is causing injustice to the scheduled caste, scheduled tribe employees? Is this? So, let us read what is the exact provision that is being challenged by the SC/ST employees. Is the GEO number 2 of 2004, and the specific provision is Rule 4, Sub-Rule 1 of the said GEO. I will read it for you, and let us examine how it is the provision in GEO 2 is very atrocious, and it is subjecting the ghettoization of scheduled caste, scheduled tribes employees, and which is against the precedents set by the apex court, the Supreme Court of India, and also against the Constitution. It also amounts to atrocity if we interpret it in right way. I will explain it later. Let us first read what is it. So this is the GEO issued by the Dadan government of Andhra Pradesh in 2004, dated 9th January, GOMS 2 issued by the Social Welfare Department. So now the specific provision is Rule 4, and Sub-Rule 1, Sub-Rule A reads like this. The persons belonging to scheduled castes and scheduled tribes who have been promoted on the basis of seniority cum merit, i.e., without applying the rule of reservation, should also be counted for judging the adequacy or otherwise of the scheduled caste, scheduled tribe representation. So this GEO says, if a candidate employee is getting promotion or appointment on the grounds of seniority or merit, but it will be counted within the quota of 15% reservation. It will not be given opportunity in open competition. Now, I would like to tell you the SC/ST Prevention of Atrocities Act, which makes it an atrocity if scheduled caste, scheduled tribes are socially boycotted by the villagers, the non-scheduled caste villagers. Now what this GEO is saying is absolutely this. Scheduled caste, scheduled tribe employees, even though they are meritorious, even though they are senior, they should stick to their own SC reservation quota. They should not come out. They should not be considered for the general seats. So now you think, apply your mind. If SC/STs are not allowed to the village path, SC/STs are not allowed to the common places like well, school, temple, that is considered as a atrocity, and it has penal provisions. Now with this GEO, if it says even though SC/STs are meritorious, SC/STs are seniors, they should be considered only within the quota of 15% SCs. So is this not atrocious that this GO being implemented by the government from the last 20 years, and thousands of scheduled caste employees are uh, retired without any promotions, and this GO being implemented in present Telangana government in the teachers transfers and promotions also, now which are going on which are started and going on in this month. So now how, so this GO is being challenged in the High Court by the some of the SC/ST employees, and what I am the court has passed an order recently stating that all the teachers transfers and promotions are subject to the outcome of the writ petition number 7091 of 2023. So even though if some people are getting reservation promotions or transfers on priority, their promotions and transfers subject to the outcome of writ petition number 7091 of 2023, because this writ petition challenged the adequacy GO, which is limiting the SC/ST employees to the 15% quota despite their eligibility to the general quota. So once we succeed in this writ petition, all the promotions and transfers which are taken place may be reversed based on this striking down of this GO. This GO certainly will be struck down by the court, because this GO is anti-constitutional, this GO is atrocious, this GO is injustice, this GO amounts to ghettoization of SC/ST employees. This GO particularly goes against the 4 judgments of Supreme Court of India. Now I will read out the Supreme Court judgments for your information. Many people are saying whether we will get succeed in this petition or not, because this is the first time after 20 years we are challenging this, and why our people, nobody has challenged for 20 years, because it may be right according to the constitution and according to the Supreme Court, according to the High Court. The 15% limiting the meritorious and seniority employees to the scheduled caste quota may be right, because of that reason nobody challenges. No, this is wrong. This limiting the scheduled caste employees to the quota of 15% despite their seniority cum merit is against the Supreme Court judgment. Now I will read out what are the judgments, and so one para from each judgment. It is not more than one para. It requires. It is a very clear case that we will win the case, because Supreme Court already said it in 4 judgments starting from 1992, Indira Sahani etc. versus Union of India and others, 16th November 1992. So in this judgment, para 94A, reads like this. Yeah, 94A reads like this. I will read out what Supreme Court said in Indira Sahani versus Union of India. In this connection, it is well to remember that the reservations under Article 16(4) do not operate like a communal reservation. It may well happen that some members belongs to say the scheduled caste get selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for the scheduled castes. They will be treated as open competition candidate. So this is a judgment of Indira Sahani etc. versus Union of India, delivered this judgment in 1992. Despite this judgment, in 1992, and another judgment, R.K. Sabarwal versus State of Punjab and others, in 1995, the Supreme Court said the para number 5 of R.K. Sabarwal Let me also read this. R.K. Sabharwal, Judgment, para 5. This is very elaborately written. When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve points, it has to be taken that posts shown as the reserve points are to be filled from among us the members of the reserved categories, and candidates belongs to the general category are not entitled to be considered for the reserved post. On the other hand, the reserved category candidates can compete for the non-reserved post, and in the event of their appointment to the said post, their number cannot be added and taken into the consideration for working out the percentage of the reservation. Article 16(4) of the Constitution of India permits the state government to make any provision for the reservation of appointments or posts in favor of any backward class citizen, which in opinion of the state is not adequately represented in the services under the state. It is therefore incumbent on the state government to reach a conclusion that backward classes for which the reservation is made is not adequately represented in the state services. While doing so, the state government may take the total population of the particular backward class and its representation in the state services. When the state government, after doing the necessary exercise, makes the reservation and provides the extent of percentage of posts to be reserved for the said backward class, then the percentage has to be followed strictly. The prescribed percentage cannot be varied or changed simply because some members of the backward class have already been appointed or promoted against the general seats. As mentioned above, the roster point which is reserved for the backward class has to be filled by way of appointment or promotion of the member of the said class. No general category candidate can be appointed against the slot in the roster which is reserved for the backward class. The fact that considerable number of members of a backward class have been appointed, promoted against the general seats in the state services may be a relevant factor for the state government to review the question of continuing the reservation of the said class. But so long as the instructions, rules providing certain percentage of reservation for the backward classes are operative, the same have to be followed. Despite any number of appointment promotes belong to the backward classes against the general category posts, the given percent has to be provided in addition. So, if a persons from the backward classes and scheduled castes and scheduled tribes, if they are qualified to be appointed in general category, they have to be appointed in general category in addition to the reserved quota, not within the reserved quota. That point is clear in this para 5, R.K. Sabharwal versus State of Punjab. So, and the next judgment, 2006, M. Nagaraj versus Others Union of India. So, this judgment also clearly says that the merit cum seniority candidates from the SC/STs should not be counted against the reservation. They should be given in general quota. So, this is equal to, yeah. So, this judgment, let me read. Therefore, if a member from the reserved category gets selected in general category, his selection will not be counted against the quota limit provided is to his class. Similarly, in R.K. Sabharwal, the Supreme Court held that while general category candidates are not entitled to fill the reserved post, reserved category candidates are entitled to compete the general category posts. The fact that considerable number of members of backward classes have been appointed promoted against general seats in the state services may be relevant factor for the state government to review the question of counting the reservation for the said class. But the when till the time the rule is there, you cannot make the merit cum seniority SC/ST employees to be count in the reserved quota. They have to be given opportunity in the general quota as per their seniority cum merit. And the latest judgment is Jarnail Singh versus Lachim Narayan Gupta, January 2022. Para 17 of this judgment, let us read. Para 17 of Jarnail Singh versus Lachim Narayan Gupta, para 17. Yeah. 2 points came up for consideration before this court in the said judgment. The first being that in case more than 14% of the scheduled castes are appointed, promoted in the cadre on their own merit cum seniority, then the purpose of reservation having been achieved. In the said cadre, the government instructions providing reservation would be inoperative. The second point which arguments were heard is that roster cannot operate once the post earmarked for the SCs, STs and backward classes are filled. Any post falling vacant in a cadre thereafter is to be filled from the category reserved or general due to retirement etc., of whose member the post fell vacant. The first point raised by the general category candidate was rejected by this court by holding that reserved category candidates can compete for non-reserved post and in the event of their appointment to the said post, their number cannot be added and taken into consideration for the working out the percentage of reservation. So, if a person from the SC/ST community is appointed on the grounds of seniority cum merit, their percentage cannot be considered for working out the percentage of reservation. So they have to be provided in general category, and 15% quota is completely different from the merit cum seniority candidates from the SC/ST communities. So this is a constitutional right which being provided to the scheduled castes and scheduled tribes, and it is being violated by the Telangana government from last 20 years. To say literally, the Telangana government practicing untouchability against the scheduled caste, scheduled tribe employees. It is atrocious, and it has to go. The GO has to go. It has to be abolished, and the section 4 of the GO2 has to be amended, stating that the merit cum seniority candidate should not be counted against the reservation quota. So in this regard, I would like to inform the people who are waiting for the case update. So the courts are really burdened with many lakhs of cases are pending, and courts are one way to achieve the justice, but courts are not only the one way. So there are several ways to get justice by approaching the government. It is not that only court should struck down the GO and then government should consider. No, it is not like that. When government understood that this GO is against the Supreme Court judgments, This GO amounts to practice of untouchability against the scheduled castes and scheduled tribes. This GO is anti-constitutional, and then government itself should abolish this GO. Why this message is not communicated to the government till now from the last 20 years? And this GO being brought in by the 2000. The then Congress government, I think, in 2004, and in 2024 we are in the same under Congress government, and it is the responsibility of the Congress government, which claims as a progressive, pro SC ST marginalized. The government has to struck down this GO completely, and it should implement reservations in spirit, letter and spirit. So, so now my last point I am saying is the case is on merits. If it goes by on merits, the case is in our favor. So the government must and should abolish this GO2, which is being implemented from last 20 years, and injustice subjected the scheduled caste, scheduled tribe employees to the injustice on their promotions and appointments. So there are 4 Supreme Court judgments which I read out in support of our case, and certainly we will win in this case. Due to the non-availability of the government lawyers, the case is postponed repeatedly, and on the last occasion the court issued an order that all the transfers and promotions are subject to the outcome of the writ petition. So my last thing, though I was telling, no, I believe being a advocate and also being an activist, I believe in not only in the court but also in the demonstrations. There are 2 ways. One is Sadak Ka Ladai, and 2 is the Kagas Ka Ladai. The Kagas Ka Ladai will happen in the courts. Sadak Ka Ladai will happen in the roads. Why the scheduled caste employees? There may be like 2-3 lakhs employees are there. Why? What is happening with you from last 20 years? Why none of you are questioning this? Why none of you are representing before the government authorities? So my point is, you make noise. Then only government listens to you. Whoever makes the noise, their voices are heard by the government. Governments will not listen if you don't speak. If the government will not recognize the injustice unless you shout out. You shout out your injustice, then only government will listen to you. And the one way is the case is in the court. It is pending, and whenever it comes on the bench, it is a big task to get the case listed in the court also. So we are team of advocates are struggling to get it listed, and making the government for final hearing also a task. And let us hope for the best for the case. But otherwise also I suggest you to make representations to the chief secretary and principal secretary school education, and commissioner and director of school education. All these are IAS officers. They must be knowing the law. They must be knowing the Supreme Court precedents. And also approach the chief minister, and he might be knowing if things put properly before these authorities. I hope they will be convinced, and they will abolish and amend this GO and do justice. It is not that certainly we will win if government authorities are not following the Supreme Court judgments. It amounts to contempt of court. So let us bring this to the notice of the authorities who are implementing the GO2 of 2004, which is illegal, which is atrocious, which is against the constitution and contrary to the Supreme Court judgments. And being a lawyer and activist, we are doing our part to abolish the GO. And you guys who are beneficiaries of the GO, those employees who are subjected to injustice by implementation of this GO must come out and speak out and approach the DOs and collectors and make noise. That is the only way. My philosophy is, uh, if you want to solve a problem, you should create a problem. Until unless you create a problem, your problems will not get solved. Nobody listens to you. If you are not able to create a problem, you are not able to solve your problem. So that is the situation in democracy. So you people should be coming out and talking about this GO wherever it is necessary, and this GO has to go. We are in 2024, and still now this GO says that scheduled castes should be limited to their own 15% despite their merit cum seniority. What is this? This is untouchability. This is atrocity. So all of us struggle together and get rid of this atrocious GO. And Jai Bhim.